you became quite famous for your dissents. There's been a long period of time where you're the most senior of the four more liberal members of the court. There was a time, I think about 10 or 11 years ago, when Linda Greenhouse of the New York Times wrote an article on the front page of the New York Times where she said that that term will be remembered as when you found your voice. And I think it was probably either the Ledbetter case or maybe the VMI case. But explain, and a bench dissent is when a justice of the Supreme Court actually reads from the dissent, when the court is announcing its decision.
A summary.
From some of it. When you do that, who is your audience? Obviously, the majority already disagreed with you. Are you speaking to the future? Are you speaking to Congress? Are you assuming that, like the great dissents of Justices Holmes and Brandeis, that the day will come when your dissent will be the law of the land? What leads you to want to read a dissent like that?
I will announce a dissent from the bench if I think that the court not only got it wrong, but egregiously wrong. And sometimes those dissents are addressed to Congress, as was true in the Lilly Ledbetter case. The bottom line of my dissent in that case was the ball is now in Congress's court to correct the error into which the court has fallen. And in very short order, Congress, with overwhelming majorities, amended Title VII so that it said with unmistakable clarity what I thought it meant all along. It reminded me of an earlier incident when the Supreme Court in the 70s said discrimination on the basis of pregnancy is not discrimination on the basis of sex. Again, there was a coalition, and by a large majority, Congress passed the Pregnancy Discrimination Act, which is the soul of simplicity. It simply says, discrimination on the basis of pregnancy is discrimination on the basis of sex. And in Lilly Ledbetter's case, well, every woman of a certain age knows what she experienced. That is, she was an area manager at a Goodrich tire plant. She, when she was hired, was the only woman area manager. One day, when she'd been working there over a dozen years, someone put a slip of paper in her mailbox. It had a series of numbers. The numbers were the salaries of all of the area managers. And Lilly could see that the young man she had recently trained was earning more money than she was. So she said, enough, I'm going to sue. She got a substantial jury verdict, and then when her case came to the court, they said, she sued too late. Title VII says you must complain within 180 days of the discriminatory incident. Lilly Ledbetter is way out of time. She waited years to sue. My theory was that every time she got a paycheck, the paycheck incorporated the discrimination, so she could sue 180 days from any paycheck. I also pointed out that what would have happened had Lilly Ledbetter sued early on. No doubt the defense would have been, It has nothing to do with Lily being a woman. She just doesn't do the job as well. But then she works there year after year and she gets good performance ratings. That defense is no longer available. They can't say she doesn't do the job as well as the men when they rated her as high or higher than the men. So now she has a winning case. But the court said she waited too long. So that kind of dissent, if the court is interpreting a statute like Title VII, then Congress can fix it. But when the court is making a ruling on a constitutional matter, Congress can't fix it. Only an amendment to the Constitution, and we have a Constitution that's powerfully hard to amend, or the court has to change its mind. But there has been a tradition in the United States of dissents becoming the law of the land. And we can go back to the worst decision the Supreme Court ever made. It was in the Dred Scott case. There was a fine dissent by Justice Curtis in that case. Or the first Justice, John Marshall Harlan, who dissented in the so-called civil rights cases in 1886 and in Plessy against Ferguson. Or you mentioned Holmes and Brandeis around the time of World War I. Those free speech cases today are all the law of the land. So you're writing for a future age, and your hope is that with time, the court will see it the way you do.